Yes, proceed. In addition, my Lord, even without order 4, my Lord, it is even in the interest of justice and fairness, which this court is supposed to uphold, that a person who will be affected must be heard. And in this case, with the greatest respect, that was flatly ignored. And so, my Lord, the point we are making, that decision or the orders founded on that refusal to hear the applicant, even when they themselves came to the court. Lord, should we not, with the greatest respect, we endorse, because the precedent will be dangerous as far as the rule of law is concerned. Number 2.
In what sense will the precedent be dangerous?
No, my Lord, the point I'm making is where a party, in fact, let me put it this way, 2 parties can actually collude and would have reached a person who will be affected. And that precedent is dangerous. And in this specific case, when the application for mandamus was moved, the judge asked counsel for the respondent, are you opposed? He says, no, I'm not opposed.
Does that make it?
No, I'm not saying so. My Lord, I will say so. My Lord, I will say so. But the point is that if this is allowed, that possibility is so grievous and present. And that is why this court must deprecate with the greatest respect that conduct.
Also pay attention to the affidavits in opposition and then the statement of case in opposition. Address them.
My Lord, with the greatest respect, I want to draw this court's attention to my Lord, exhibit attached to our judicial review. My Lord, we attach exhibits, that's the Republic vs. Cyprus, the Electoral Commission respondents, National Democratic Congress. My Lord, it's in the supplement. Yes, so my Lord, I'll be very specific.
The protocol we have created for us, the exhibits, I have them as B, and my other guy has as A or C. The protocol we have created for us.
My Lord, I'm sorry about that. My Lord, that should be exhibit D in our supplement. Is the application for judicial review by the NDC.
As you make the point and let's see if it will help us locate.
Okay. My Lord, in the third exhibit, the applicants had applied for judicial review, whereupon they have indicated that there have been declarations in their favor with video evidence of those declarations. With video evidence of those declarations.
Yeah, but those were not before the judge who determined the mandate.
They were before him. That was the way before him. Yes. I stood up. Yes, my Lord. That's the unique thing. I I stood up and brought to his attention that, my Lord, pending before you is this application. So we even found ours on the 16th. On the 16th of December, this mandamus application was found on the 17th. But my Lord chose to hear the mandamus that was found on the 17th. Yes. He was in the court and before him.
Please, the two are not the same. Was it pending in that court or it was right before him?
My Lord, it was pending.
Say so.
And he was hearing that same day.
Or it was listed for years?
Yes, that same day. So I stood on my feet and drew my Lord's attention. But my Lord, these are declarations with video evidence. So consider my application first. He ignored it. I was respect.
Yes, you see, some of the facts being introduced are indeed erroneous. They are erroneous. And I think it's fair that I put them in context. But let's see fact.
So you can read.
No, yes, hold on. What he found was not before the judge. It was not for the judge.
No, it may not be on that docket. It may not be on that docket, but it may be in a separate docket.
No, you came to court holding the documents.
No, we're talking about the second application. Or the first application, the one they filed on 6th.
The one they filed.
The first application. Okay. So Mr. Thomas, the first application.
The man he had before him. When I brought it to my Lord, he indicated that the docket was just brought to him the evening, together with my learned senior. After he had granted the mandamus application, he now asked me to call that.
Oh, okay. So he heard it.
Yes. In fact, I even made a prayer that, my Lord, I beg you, what do he do? He said he won't do it. And started giving his ruling. So, my Lord, at this point, clearly before my Lord, was evident that some people have already been declared that will definitely affect their rights. Lord, on the grounds of bias. My Lord, the point we make here is that at the time, with respect, my Lord was considering the mandamus application. He knew that any order would immediately affect the application which we have exhibited, which was pending before him, but gave a decision in such a way that by the time he is done hearing, our application for judicial review would have become moot. Manifest bias. Number two, the mandamus application in one breath My Lord says our gender on page 2. Offense understated resorting of CI 47. However, my lords, the mandamus application that was granted with respect had no statement of case attached. So in one way, my Lord was holding us to the strict compliance of the rule, but in the other breath, waive it for the interested party. My Lord, without the statement of case, the court jurisdiction for the mandamus was not properly invoked. And so the orders sounded on it were definitely done in excess of the court's powers or its jurisdiction. We submit.
What is your authority for saying that?
Now, 65 will say 2.
It says what?
6-2. The court may, on the hearing of an application for judicial review, then 2, within 14 days after the filing of the notice of application, the applicant shall file such numbers, set copies of the applicant's statement of case. And my lords, this court, in the case of God, my Lord said, what's the authority? Of course. And later, I didn't quite a second. And Thomas Okan, number J4 and 20. And Thomas Okan, civil appeal number J4. It's Lordship Justice, but they have this to say. That when J4/20/2009, it was dated 29th April 2010. Says, quote, where the rules of court prescribe a particular mode of seeking relief, then a failure to initiate the proceeding for relief in accordance with the prescribed mode is not only an irregularity, but raises an issue that goes to jurisdiction. Now, in excess of jurisdiction, specific. In the case of Francis Owusu Mensa and another, versus National Board for Professional and Technical Examination, civil appeal number J4/57/2017, dated 1st May 2018. It was held 57. The Nearby GLC, as it then was, had this to say: a court may have jurisdiction to entertain a cause or matter, but the procedure invoking its jurisdiction may deny the court's jurisdiction. In this case, the court, the High Court, has the jurisdiction to entertain a mandamus application, but the rule says at the hearing, a statement of case must be attached to the application. That is how the court jurisdiction is invoked. Mr. Tanakru, my lord, even in this court, your colleague raised a fundamental issue. Let me
no objection, which we have waived.
Oh, my Lord, I told you that you are going to waive this one.
And we said that no,
my Lord, when you waived, it was on record as having waived it.
so it's
In this case, my Lord, the ruling of my Lord is before you. The court never said they are waiving that non-compliance. My Lord, the court never said that. It is a different thing if the court, in exercising its powers, gave an indication on record that it is waiving that non-compliance. That was not done. My Lord, it's a court of record. My Lord,
I wish I could. Does it matter to you that the other side did not file an affidavit in opposition? Does it matter to you?
yes, my Lord.
That the EC before the High Court was not opposed to the application.
My Lord,
The waiver even started with the EC.
no, my Lord, the waiver is not one that the party should raise, with the greatest respect. It's not one that requires that a party should raise an objection to the non-compliance.
The party may raise it.
Yes, I'm saying that without that, this court is required to consider it. Yes, my Lord.
Which one? On the your non-compliance with the rule.
The party are not on bread.
Yes.
But there was no exhibit attached. So the issue of certificate of exhibit does not even arrive. But my Lord said we had offended the rule.
Okay.
My Lord, 2. Ex parte Nana Equia Urusu Efriye. That one, we attached a video recording of the declaration, and there is a certificate of exhibit attached. But my Lord simply says he is applying the ruling mutatis mutandis. I want to bring to your attention the decision of this court in the Republic versus High Court Bordatanga. Ex parte Howard Yakubu, 2001-2002 Supreme Court of Ghana Law Report at page 553, sorry. The Supreme Court had the occasion to quash the orders of the High Court in Bolga because the court said Howard Yakubu, who had been declared winner, was not a party to the petition, but orders were made which adversely affected her. Even though she was not a party, the court said she had the right to be heard, and that right was breached. And all the orders made by the High Court in Bolga were quashed. And the resulting effect that all the consequential orders having been founded on those orders must collapse with it. My Lord, the affidavit in opposition filed by the first filed by the Electoral Commission. The position made is that because because the applicants were not parties at the time the application was heard, they deserve no rights, or there is no issue of breach of the rules of natural justice. My Lord, that is completely far-fetched, because the application for judicial review, which had the video recordings of those declarations, was duly served on the respondent. The respondent came to court and said they were not opposed. They never filed any affidavit denying those declarations. Or if he only stood up and said he's opposing it on point of law. The factual basis of the declarations were never denied. So they claim that they were not parties and therefore should not be heard. There is a new. And that is exactly the decision of the Supreme Court in Espati Hawa Yakubu. My Lord, at this point, my Lord, I want to make a brief prayer that certain depositions in the affidavit in opposition by the Electoral Commission deposed to by Mr. Samuel Tete be expunged from the records of this court. Why? My Lord, these are matters that are not within his personal knowledge. He is not the returning officer of any of the constituencies named.
I think he preceded his affidavit by stating that within his knowledge and information, didn't he?
One of the point we are making is that, with the greatest respect, my Lord,
Yes.
one, he does not attach any official record or official document to the deposition or a police report by any of the returning officers detailing the so-called
that weakens the weight. I don't think we.
No, my Lord, I just want to bring it to us that those depositions should not be very respected.
Oh no, we said that. The man stated that to his information. And if you think that it doesn't actually establish a fact, that is a different matter. But you can't. Don't say we should expunge it.
My Lord, the respondents say they had already done the collation. And so what is the point? You considering our application. My Lord, the morning of that Friday, with the greatest respect, I had appeared at General Jurisdiction 6 with my learned senior Justin Amenuvo and Gary Lumako, where there was a pending injunction application against the Electoral Commission
Before the closing application.
My Lord, so far, various allegations have been made in this court in the course of his submissions, which have not been deposed. I hope that when it gets to my turn, the court will permit me to give alternative facts, because he's been going on and on and on.
Counsel, if he is saying something which is not in his affidavit, it is your obligation to point it out, and then we would do the needful. So anytime he's going beyond his affidavit, draw our attention. Yes, Counsel.
Please restrict yourself. Let's go on. Yes, my Lord. So, my Lord, so our response is that at all material time, there was a pending injunction application that we had all appeared before the judge and gave us my Lord, this is not before the court.
Okay. So you haven't deposed. It is not in your affidavit. You haven't deposed to it. So let's go on to another point.
My Lord,